welcome to another edition of Crime News with Mark Solomon. It is Monday, Labor Day, September 6th, and today we're going to do a question and answer video. I'm going to go back into all the questions that I've seen that I have not answered in the comments, and we're going to deal with them today. So if you've asked a question, you're probably going to get an answer now. Stay tuned. But before we get to that, don't forget to click like and subscribe with a little bell next to it to be notified of future videos like this one. You can be the first to see it if you click that bell. So let's get to it. First thing I want to talk about is a question from about 23 hours ago by C. Carter. A really good question here. And Windy Wednesday said, these are good questions. I agree. His question is, I have a legal question. Was Pryor, Chad's attorney, allowed legally to set up the interview, coach the children, and or allowed to write up the guidelines of the interview that was allowed and wasn't allowed for the reporter to ask? Well, that's a really good question. First off, the attorney can certainly set up an interview if they want. There are definitely some ethical issues where the defense attorney is not allowed to make statements in regards to an ongoing case if it's going to prejudice the jury or the venue. One of the things that you're going to see in most cases is that sometimes police departments make statements to the media, and the defense attorney is allowed to counter those to keep the jury pool neutral. Sometimes prosecutors can make statements in regards to what charges have been filed, what's coming out. These are public interest issues to where they will usually not make statements about the facts of an ongoing case because ethically they're not allowed to. But sometimes even the district attorney's office or the prosecutors have to make statements to clear up what's already come out in the media, and that's important. So the first answer is, can they set up the interview? The answer is yes. The next question, can they coach the children? The answer is absolutely not. That is literally the same thing as making a statement to the media, and that is literally just akin to tainting the jury pool. Next question they ask is, are they allowed to coordinate what questions are allowed and which questions are not? This one's a little bit trickier, and the reason I say that is because, in general, lawyers are not allowed to obscure access to witnesses. But in this case, if they're coaching the witnesses, which is an improper thing to do, telling witnesses what to say or what to do, then the act of coordinating a public statement by the witnesses, especially from the defense side, basically exculpating or making their client look less guilty, is going to be a huge ethical problem. So I would say that's a big no on that. Next question is Chad allowed to visit and communicate with the children even though they will likely be called as witnesses? Again, really good question. And the answer is, the kids can visit their father. I have represented so many people who have had plenty of contact with their family, the witnesses in the case. Heck, I've done a lot of domestic violence cases where the defendant was allowed to live with the victim because they were still getting along, they're doing great, and there's no reason to keep them apart. Even if there was a protection order, the protection order did not prohibit them from being in contact with each other. So there's nothing wrong, absolutely nothing wrong with Chad Daybell communicating with his children. What he is not allowed to do is, at least under Colorado law, he's not allowed to preclude them from being witnesses. He can't tell them what to say, and he can't keep them from being served a subpoena to be witnesses. In Colorado, any of those three acts would be an act of witness tampering, which is a Class 3 felony, pretty serious. Obviously, it's not as serious as the murder charge that he is facing. But the answer to that, is he allowed to visit and communicate with his kids even if they're going to be called as witnesses? The answer is yes. If he wants information conveyed to his children, is he allowed to have his attorney give them that information? Absolutely. As long as there's no protection order prohibiting him from having contact with any of the witnesses, then he can have the contact. And any time that there's a protection order prohibiting contact between two people, the lawyer isn't allowed to violate that either. But in this case, I do not believe that is the case, so I think his lawyer would be allowed to pass messages anytime they wanted. Next question, or statement rather, the interview seemed very scripted with a narrow focus that seemed to be transmitting a perspective that his attorney was trying to set up as a legitimate defense. And I agree, but it doesn't have to come from the defense attorney or the defendant. Oftentimes you have witnesses who have picked sides, and in this case, they're on the side of their father. And if they want to come out with a statement, there is nothing prohibiting a witness from doing that. They're not under the jurisdiction of the court generally, so the court can't really even give them orders, even though this thing is set for trial, even if they've been served subpoenas and they're under the jurisdiction of the court for the purposes of becoming witnesses. In general, the court's orders in regards to what witnesses can and cannot do generally start when they enter the court. So in other words, you'll have a sequestration order that generally starts about the time the trial starts. That's where the jury, the defense attorney, the defendant, and any of the witnesses who are likely to be called as witnesses are ordered not to talk to each other. They're also ordered not to talk to anybody else about the case. And so that's why you generally have witnesses show up at the beginning of a trial so that they can all, A, make sure that they're there, number two, make sure that they get that sequestration order, and number three, are under the jurisdiction of the court. So if they violate any of those orders, they can be held in contempt. So Mr. C. Carter or Mrs. C. Carter or Ms. C. Carter, I appreciate those questions. I agree with Wendy Wednesday. Phenomenal, great questions. Thank you so much for asking that. Here's a question by G-Maps, a.k.a. Katie, a.k.a. Mary Kate, from 1 week ago. Hi, Mark. Question: what is the difference between an arrest affidavit and discovery? Does defense have the arrest affidavit but won't receive full discovery until a certain time, or are they both pretty much the same thing? Donald Lambert took a stab at this answer, and I like this one, so let me just explain this from the beginning. An affidavit for an arrest warrant accompanies an arrest warrant and has to spell out probable cause for the sole purpose of giving the judge enough information in that arrest affidavit to find whether probable cause exists so that the judge will either issue the arrest warrant or not. In Colorado, we have warrantless arrests where they have a probable cause statement, which is the exact same thing as an affidavit for an arrest warrant. And either way, it has to have probable cause that a crime was committed and that this is the person who committed it. And if the judge grants that, then the arrest warrant is issued. In the case of discovery, that's all the information that the prosecutors accumulate for the purposes of prosecuting a defendant. So in other words, you'll get things like police reports, witness statements, body camera recordings, forensic analysis. You'll get lab results. You'll get all the sorts of CSI information that the prosecutors are going to use to be able to secure in their mind, they're trying to secure a conviction. And so discovery is everything that the prosecutors have against the defendant. It will also include, by requirement of constitutional law, any Brady materials. There was a case many years ago where the Supreme Court has held that any exculpatory or anything that makes the defendant look less guilty, the prosecutors have an ethical duty to disclose that to the defense. So in other words, there was a very notable case here in Colorado. It was the Masters case where a man was convicted of a murder, and the prosecutors failed to turn over the fact that they collected multiple DNAs. They took DNA samples of things around the house, and they found at least one unknown DNA sample, and that they did not turn that over to the defense. By not turning it over to the defense, the jury never got to hear that there was a possible alternate suspect, and therefore that case got reversed. So when you have discovery is everything exculpatory by necessity, and it's also everything inculpatory that the prosecution is going to present. Good question. And Donald Lambert's answer is that the affidavit is kind of right to the point accusation, and discovery holds lots of details, maybe has more things found out since the arrest. And so it's a good generalization, but just remember, discovery is everything the prosecution has. The arrest affidavit is everything to substantiate probable cause to begin the case. So it's a good shot. Here's a really good question, and I'm going to try to pronounce this right. K. Amari from a week ago on the Barry Morphew case. Do you think the prosecution held back damning evidence for the preliminary hearing that proves Suzanne's death? And the answer is, It's possible, but I really, really, really doubt it. And the reason why is, in a circumstantial case where it's technically possible for the judge not to find probable cause if they cannot prove that Suzanne is dead, then the prosecution would literally want to make sure that the judge had no option but to grant the probable cause, hold that it exists, and bind the case over to district court. So do I think they did it? No. Technically, could they have? Sure. But usually prosecution offices do not want to take that risk and have their case kicked at the preliminary hearing. So no, I do not think they did that. I think they're pretty much, I think they're throwing everything into the case. That's why there's that 130-page affidavit for the arrest warrant and a 4-day preliminary hearing, because they really don't want to take the chance that the judge will not bind the case over. Good question, though. Very good question. Here's a question on the Barry Morphew case by Ann Lane. How do they explain Suzanne's purse, wallet, and credit cards and money being inside her car? It's not normal to leave that there unless she was leaving her car when she was abducted or suffered foul play. There were some good answers here. Very good question. There was also a backpack in the seat, says Daniela Hody. If not staged, she was definitely going somewhere. Ann Lane responded, I can't believe law enforcement didn't focus on this. Donald Lambert says that's another strong indicator that helps most of us to believe that she was murdered by at least somebody, but this point alone does not prove it in court. Donald Lambert also says that she could have put those things in there to be ready to leave, so if Barry got angry with her, she could walk out the door in an argument and say, I'm going for a walk to cool down, and then just leave. You know, when we talk about that truly circumstantial case, remember, circumstantial evidence in Colorado has the same weight, possibly, as direct evidence. And I talked about that on my video a few days ago. Basically, anytime you've got somebody where the circumstance of their disappearance strongly suggests that they didn't just walk out, that's what they're going to prove. That's what the prosecution is going to try to make the connection to. So in other words, when you've got somebody who has all of their means of supporting themselves left behind and the person is gone, circumstantially, that's what I was talking about as far as their personal, financial, and social trail going cold. In other words, most people don't just up and disappear and leave everything behind. It happens. But again, in this case, it's the prosecution's burden to prove that that's not what she did. Good question, though. Here's a really good, and I think this really sums it up well by Nick Schwartz. Crime scene could be anywhere. She could be alive. No evidence. She's dead to me. Someone else could have her, or she could just be gone. She covered up the affair for the FBI for 6 months so she could disappear without people knowing. He could have killed her, but just not strong enough. And I think that's the big back and forth on this case. Will they be able to convince a jury that she's dead and that he killed her? Here's another take on the Barry Morphew case by Jesse Diane Ryan. Will you do a critique of the prosecution's case? Some on YouTube think they have not presented much to get a guilty plea. And remember, and I think what Jesse Diane Ryan is saying, enough to get a guilty verdict. Maybe he pleads guilty. Those are two different things. If he decides not to fight the case, or they make an offer to avoid a trial, maybe he does plead guilty. Maybe it's to the charge. Maybe it's to something less. We'll see as time goes on. My videos on the Morphew case really have been a critique, and I think that what I've been seeing is a lot of very good circumstantial evidence that she's been the victim of foul play. And when they can present enough character evidence that she knows all these people and nobody has heard from her, that's really good circumstantial evidence that she didn't give up her entire life, all of her ties to all of her family, all of her friends, all of her employment, all of her finances, and just leave just to get away from him, especially when she had somebody else she was seeing. It seems like it's a far-fetched but not impossible defense to say that she has simply given up and moved to Mexico or Canada or whatever. It seems like they've got a good case. But that's what the jury's for. And remember, we are only seeing 4 days of it from investigators, and we are not hearing from the actual witnesses themselves. That's what jury trials are for. They're for 12 people to sit, listen to the evidence, determine what they think happened, to determine credibility. And I think that's what this case is going to be about. I'm not the defense attorney on the Morphew case, obviously. They know more than anybody else in the case, because remember, they know everything the prosecution has, and they also have their own side of the story, plus any experts that they're going to be talking to, plus any witnesses that they've already interviewed. And so because of that, the defense attorneys are always going to know more how good or bad of a case it is, and we have yet to see that. So if Barry Morphew decides to plead guilty, if the prosecution decides to offer him something that does not involve life imprisonment, that's going to be an interesting turn. But for now, we have not heard that. Here's a question by Marlene Barone. How did they know about all the garbage drops, and was law enforcement able to get any of it? And Maui Swift responded, we don't know that yet. Alex Perkins correctly said that they had video surveillance and also GPS pings. Absolutely. What they did is, little known fact, we all have GPSs in our cars, and they track where we go. In this case, the FBI was able to download the GPS down to their system, find out where he went, and it was recent enough to where they could go and get the surveillance videos surrounding those garbage dumps, and that's how they were able to put all this together. Did they get the garbage? I do not believe they did. If they have, that has not come out. Anna Borden asks, about a week ago, is there any information on poor little Summer Wells? Cynthia Wilson also wants to know, and this is about a week ago. My video about 3-4 days ago, unfortunately not. The reward is still up to over $38,000 for any sort of successful leads that lead police to either find her remains, or anything else that would help them solve this ongoing mystery. Here's Karen J. on the Morphew case. Why would a person not dump all your trash in the same place, but then go to 5 different locations? There are too many coincidences and so many incidents. Cynthia Wilson agreed. I've had a number of other people say, well, there is actually a decent reason why somebody might do that. First off, people get charged for their trash, and if they have too much of it, it costs more. So he took it to some commercial dumps to get rid of it. And why did he go to 5 different ones? It's entirely possible that he was getting rid of evidence. It is also possible that he was just being nice to the people whose dumpster space he was essentially stealing from. And instead of dumping a whole lot of things in one dumpster, he was putting it in 5 different ones to spread the load. Because remember, it is illegal to dump your trash into somebody else's dumpster. That's a commercial dumpster. Somebody else is paying for it. It's illegal. So if he mixed it between several different dumpsters, people would be far less likely to complain with an extra trash bag as opposed to 5. That's the alternate explanation. Here's a question by Aloe Vera saying, thank you very much. My question is, why is the affidavit still sealed? Will the judge release this to the public on September 17th? The judge doesn't want to let too much information into the public because the district attorney asked for that. And they have a good reason. I do not believe they've released that reason, other than the fact that they are still trying to keep somewhat of a neutral jury pool and not to contaminate the jury pool. Remember, Chaffee County is a really small place. And if enough people were to see a 130-page affidavit, they'd already make their minds up before they went to the trial as potential jurors, which would make it even that much more difficult to get neutral, unbiased jurors who have not heard the facts of this case. Good luck. It's going to be difficult. A lot of people have been reading about this case. This video is point proven that people are talking about it anyway. Here's a question by Judy Johnson about a week ago. I think he learned of her affair, and this is on the Morphew case too. I think he learned of her affair just before the daughters went on their camping trip. Why would they go on a camping trip at that time when Mother's Day was only a few days away? In my opinion, he knew about it and didn't want the daughters around as he had already planned everything out. Very, very reasonable conclusion. Or theory. Sharon, the Fifth Dimension, says exactly. He had them intentionally out of the house. Sadly, they remained aligned with Barry. It's going to be a rough time of cognitive dissonance when they eventually wake up. Judy Johnson agrees. Here's another section, a comment to the comment. Jay Arrington says, playing devil's advocate, it may have been pre-booked, as it sounds like a lot of people went. And I definitely believe he knew about the affair. The randomly adding men to Facebook from school is suspicious and doesn't sound like her personality, as she's been in a relationship with Jeff. But I think he either found out she was dating someone from school and she added loads more guys so that he didn't know which one it was, or he found out but didn't know who it was and was fishing. Absolutely reasonable. Here's a question from about a week ago by Mr. Meaner. This is on the Summer Wells case. Don is saying that the neighbor heard a scream now. How come he's only now just coming out with that? That should have been one of the first things that got mentioned. Couldn't agree more. And if he's not saying it out of personal knowledge, who told him that they heard a scream? Was it the mother, the grandmother, or one of the kids? That's pretty darn fishy. Rainy Joe from 2 weeks ago saying, how am I just finding out about this channel? You're really good, and I appreciate your open-mindedness and all the research you do. Well, thank you very much. I appreciate the fact that you're writing that. I do. I spend a lot of time on these videos, and it's good to hear that. Thank you so much. Also, I wanted to add that I actually believe Alex did already have the blood clots present. Now, we're talking about Alex Cox, Lori Vallow's brother, who did kill Charles Vallow in self-defense, he claims, and died himself on December 12, 2019. And the medical examiner had ruled this as a natural cause from bilateral pulmonary embolus, blood clots in his lungs. And this viewer thinks that before the day he died, I do think Zulema did him in for Lori. The reason I think that is because he had blood clots is because he was a truck driver who sat a ton. And he also had just gone on a couple long road trips prior to his death as well. But I definitely do not believe that he coincidentally died one day after they exhumed Tammy's body. So whatever they did, they definitely masked the blood clots, in my opinion. Great job, liked and subscribed. Thank you so much. I appreciate that. Here are a couple comments. Bling Bling Crafter from 2 weeks ago says, since you're pretty sure this will go to a trial, do you think they will let the media in to record? If so, will you be airing live on your YouTube channel for us? And also, Wendy Essler says, do you think Barry Morphew will be held over for trial? Same thing. We're talking about Barry Morphew on both of these questions. First off, I think this is going to go to trial because he's facing the life imprisonment. And the only way the prosecution's going to avoid a trial in this case is to offer something else. And the only way that happens is if something happens to the prosecution's case where they don't think for sure they're going to get a conviction. And oftentimes prosecutors are willing to offer something that they're not happy with so that they don't run the risk of letting somebody who they believe committed a murder go free, which is what would happen if he is found not guilty of all the charges at trial. Will I be airing live on my YouTube channel? The answer is almost certainly not. I'm a working attorney. I have got to be other places. If I can, I would. But here, the first part of your question is, do you think the judge is going to let people in to record? I do not believe he is. And the reason why is, number one, we are still amidst a pandemic and the social distancing in courtrooms is still real, even in Chaffee County, Colorado. Will they let the media in to record? I do not believe so. Remember that this judge was very hesitant to allow the preliminary hearing to be recorded and set some very, very, very stringent guidelines as to how that was supposed to be done. So I do not believe this is going to get wide stream recording because of that. I think the judge is doing his best to control the court, which is the primary job for the judge. Control the court. Here's a question by AR from 2 weeks ago on the Barry Morphew case. Mark, do you think it'll be brought up in court how Barry tried to have Suzanne declared legally dead only after a few weeks of her disappearance? Absolutely. I think that bears directly on his state of mind and what he was trying to accomplish. And his feeling that he was no longer looking for his wife within just a couple weeks of her disappearance. I think that's absolutely relevant, and it does show where he was as far as his state of mind, the accused murderer in the case. This viewer says Barry approached her ailing father for help, but of course he wanted no part of it. The motive obviously being for money, so he could sell the house and properties that were in Suzanne's name. And that's a perfectly great reason for a prosecutor to bring this information up. Motive to commit the crime. Absolutely. Lori Dunn from 2 weeks ago asked, we don't know if they have DNA, right, in the Barry Morphew case. And Ann M. H-Town from also 2 weeks ago replied and said, they said no blood was found, but DNA, pieces of hair, skin, and nails, we haven't heard yet unless I missed it. The only DNA evidence that I've actually heard of is coming from the defense, and that's the several different unidentified DNA samples that were in Suzanne's car, which I don't believe. It's an alternate suspect, but again, how many times have people been in our cars, people working on the cars, they touch something, they sneeze, and they leave DNA behind? I don't think that's very convincing. Here's Kimberly Wood, also on the Morphew case from 3 weeks ago. The part of the case that I keep coming back to is this. She leaves town not once, but twice, but 7 times to meet her lover. Why return? If you ask anybody in a domestic violence situation, they would leave everything behind but the clothes on their backs to get the heck out of there. If it's money she really did die for, a couple $1,000,000, I can't wrap my head around staying when she had already left and her kids were grown. I hate to think she stayed for the money. Hope responded, I think the youngest daughter wasn't quite old enough for her to feel comfortable leaving. And you know, when we talk about people and domestic violence situations, there are patterns, but everybody's different. Every single human being treats these situations differently. I don't know if we know this was an actual domestic violence situation. At least I haven't heard that. But we know that he was emotionally controlling, if nothing else, from what I've read. Her being in an affair is definitely important when it comes to why she would want to leave and why she would come back, is because she didn't think that was a problem and she was starting the process of leaving him. Hence the text to Barry saying, I'm done. And that was purportedly ending their marriage. So it's one of these situations where if it was truly a domestic violence situation, they often do come back. Some people leave the first opportunity they get, but some people don't. And other times they go back and forth. So I don't think that's, you know, Kimberly Hood, I appreciate where you're coming from, and I appreciate the fact that you would leave, and I think that's a good thing. If there is a domestic violence situation, the best thing to do is to get out of it, because most experts do agree that these things do escalate. And if this was a domestic violence situation and she didn't leave, obviously, this did escalate, and that's what he's on trial for. Here's an interesting couple questions. These are from 3 weeks ago on the Morphew case. Judy McGuire says, if he loved her so much, why was he in a hotel room on Mother's Day when he should have been planning a steak dinner? Hope responded, yes, and initially he was supposed to be alone on this job with a young female worker of his. According to her, what if Suzanne got wind of that? Bluebell Blue, 3 weeks ago, also asked, why was he staying in a hotel? Good question. I think it also comes back to Barbara Henninger asking, is Liebler going to get in trouble for keeping quiet about his relationship with Suzanne the whole time people were desperately searching for her? He never came forward and had to be contacted by law enforcement. Also on cross-examination, a lot of the evidentiary items you mentioned had plausible explanations. I don't think it's going to be as much of a slam dunk conviction, just my hunch. And I agree. Anytime there's this type of circumstantial case, he was staying in a hotel. Why? When? Was he alone? Was he supposed to be planning the steak dinner that he said he had with 2 plates and then just one? Why didn't Liebler come forward sooner, especially if maybe he was scared of Barry Morphew, didn't want to get into the same situation that Liebler thought Barry Morphew put Suzanne into? It's possible. And he just wanted to not get involved. And I think when you have somebody with their own personal safety, that makes perfect sense to me. So here we have a situation where the prosecutors are trying to convict Barry Morphew for murder. They're also trying to convict him for tampering with the human remains because they never found it. And all of that is circumstantial. They are really going to need to close the loop on the notion that she just left. Here's another one by Dusty Blue. Barry wouldn't be in the predicament if he simply had agreed to divorce Suzanne. Will he be proven guilty or not? Only time will tell with the evidence presented. Couldn't agree more with that. Here's a really good question by Dot to Dot. If you're innocent until proven guilty, why do you not remain free until the same? And the answer is bond. Here's the thing. a lot of people are charged with a crime. And what bond is supposed to do, at least in theory, two things. Number one, it makes sure that you keep coming back to court. And number two, it makes sure that you're not a public safety if you are allowed to be released. The more serious the case, the more likely you may not want to come back to court. And the more serious the charge that you're charged with, the more likely that you might not be safe to be out and about walking around in public. I've read, I'm sure all of you have read a lot of cases where somebody was out on bond facing a very serious charge and they committed more charges. And the first question the public legitimately should be asking, but for both the judge and the prosecutor, is why was the bond in such a way to where this person was allowed to be free? Because obviously they were a public safety hazard. Think about DUIs for a minute. If you get a DUI, your bond is not going to be very high at all. But if you're on your fifth DUI case, you're a public safety hazard, because if you go out and drink and drive, then it's at least partially the fault of the courts and the prosecutors for not protecting us for this person who seemingly cannot stop from drinking and driving. And so when asks, why are you not allowed to remain free? The answer is, in a case of a murder, especially in Colorado, there's that part of the preliminary hearing which allows the judge to hear enough evidence about the case from witnesses to decide whether or not this person should have a bond. Because remember, if they're convicted, they are facing life imprisonment, no parole. Why would a person come back to face that charge if they just ran and wouldn't face those charges anymore? And the answer is a big, big, big bond. You know, hundreds of thousands of dollars you've put up for the privilege of being able to walk away from the jail. And it's not uncommon to have a 7-figure bond in a murder case. And in this case, that's what the judge is going to have to make a decision on. So, that's yet to be decided. He may be able to walk free while facing trial. Here's Jeannie M. says, new to your channel and love it. Again, thank you very much. The content, the tone, and the delivery are spot on. Do you have or contemplate a podcast? Interesting question. I've actually looked into it. I haven't decided whether I am going to or not, but I've definitely looked into it. If anybody wants me to look into it more, please, please, please let me know. And I may very well do that. If it makes sense, I will do the podcast. Here's a comment by Just Love Laugh LO Seed from a month ago in the Summer Wells case. What if the dogs did bark and they did not think anything of it? Might have thought it was a rabbit or a squirrel. Good question. And so, you know, but they never said that. They never said, we heard the dogs barking and we didn't think anything of it. So I think this is one of those situations where somewhat similar to the British system, to where I've seen this on British TV shows where they give the advisement to people that the police are questioning. You don't have to talk to us, but it may harm your defense if you choose not to say something and then later rely on it in court. And I think this is one of those situations to where, granted, there's no burden shifting. They don't have to say anything, but why didn't they mention the fact that they didn't hear that they heard something and didn't think anything of it? I think that's a little bit strange. Darlene Shriver, also on the Summer Wells case. I have heard that they didn't want their property searched. Is that true? And if so, why? That's usually where they start. I didn't hear that. In fact, what I did hear is that the Wells folks were really excited about having the police there, but they felt sad because they never thought they were going to find anything. I think that's more strange than not wanting to be searched in the first place. But Darlene Shriver, thank you for the comment. Good thought. Okay, I think I've got time for one more. Here's P. Mal Shern, who asks, didn't Candace say that her mom was in the hospital for knee pain? This is, again, Summer Wells. Okay, this brings up another question. Why wouldn't Candace have brought her mom home so she wouldn't have been in the car with Candace and Summer? And, you know, didn't Candace say that her mom was in the hospital for knee pain? I actually had read that Candace was at the doctor's office to get a prescription for the pain. And why wouldn't she have brought her mom home so she wouldn't have been in the car with Candace and Summer? And again, that's why they had stopped at the swimming hole for swimming. This is where we had heard from several other sources and a number of viewers that it was Summer who had slipped and hit her head on a rock, and then they had gone home. So there was that other situation to where how long was she underwater was one question. The second question was how hard did she hit her head in that fall? And the third question is where did she go? The next question is, can we expect some film footage and other facts to be released from the officials? Again, Summer Wells, and I do not believe so, because they are not getting too much farther on this case from what everything I am reading. Last question we're going to do on today's video is from Angel on a Mission. Again, Summer Wells from 1 month ago. Why would a little girl who loves the outdoors so much all of a sudden want to go to be inside with her brothers and immediately change her mind and want to go down to the basement to play with her toys and then immediately decide to go out the basement door, all within 2 minutes? I wish I had an answer to that. I think that's pretty suspicious. I think that's one of the biggest reasons to why I find that account by the mother and the grandmother and then repeated by the father, Don Wells, to be so fishy. Way to nail it. Angel on a Mission. I agree with you. Why? So that's what we've got for today. I really appreciate all the viewers with the questions, comments, and thoughts. If you have any more questions, comments, and thoughts, put them in the comments below. Periodically, I'll do exactly what I just did today, go through it and answer all of your questions. So have a wonderful Labor Day, and thanks again for watching.